Hello, this is Matt on the Moon Lambeau channel. Attorney Jeremy Hogan, who runs the very popular YouTube channel Legal Briefs, put out a brief tweet in which he shared his opinion on what he thinks will make the SEC most likely to settle with Ripple. Which is what I think most of us want. I mean, yeah, okay, fine. In an ideal world, we'd love to have full justice, meaning like full adjudication, setting precedent for the entire crypto space. Yes, yes, yes. But if we could get clarity sooner, and we could potentially, the only way that's going to happen is through settlement rather than full adjudication. So it's going to be good for XRP holders either way. I certainly suspect. I mean, either way, whether the court case actually goes all the way through and we see what the judge has to say at summary judgment or it's settled. Either way. But yeah, for the rest of the crypto sphere, not going to be that particularly helpful unless there's something precedent setting here. So what is going to make it most likely for the SEC to settle? Well, I want to share with you what Jeremy Hogan said, as well as some additional thoughts and the implications of this, because it's actually a very big deal. But it has to do with Ripple's fair notice defense. So anyway, plenty to talk about in this latest Moon Lambeau hot jam. But before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So I want to mention a few things before I highlight Jeremy Hogan's comment and then talk about that a bit, which is the core of what I do want to discuss. But I want to set the table just a little bit and make sure that people have sufficient context and understand just a few specific factors that are really important to get in this case before jumping into that. There's a video I put out, I guess it was, I don't know, maybe it was 2 days or so ago, with it just had the latest SEC versus Ripple legal updates, in which I highlighted that the judge's latest court order, in that she slapped Ripple down in regards to their nearly 30,000 requests for admissions from the court. But they had a notable victory regarding their interrogatories, in which the judge ordered the SEC on various topics to answer Ripple's questions. And previously, they were just dodging everything that they could. They answered almost 0% of Ripple's questions, and the court wasn't having it. And so, the judge ordered the SEC on various topics to answer Ripple's questions, as well as provide just necessary clarity. And so the judge noted that Howey factors are highly relevant to this case in her court order. But what does that actually mean regarding legal clarity for XRP and Ripple's legal battle? Well, attorney John Deaton's crypto law organization tackled that on Twitter, sharing information about what the judge expects and highlighting that the SEC's conversations on Bitcoin, Ethereum, and XRP are highly relevant to Ripple's fair notice defense, which is why I want to quickly run through this first, and then I'll jump right into what Jeremy Hogan had to say, because that's what I'm most interested in here. But I want to highlight this. So here's a very short thread. I'm only going to go through a short portion of it. It's lengthier than what I'm going to cover here, but I want to get to the meat of it here. And so here's what Crypto Law tweeted out the other day. If you're new to the SEC versus Ripple case and you're trying to understand the latest order from Judge Netburn and the Howey analysis being done on XRP in the context of fair notice, remember the judge's April 6th order on Bitcoin, Ethereum, and XRP. And here's a screen grab. And this is from the judge. I think that the discovery related to Bitcoin and Ether is relevant. I think it is relevant to the court's eventual analysis with respect to the Howey factors. Yes, indeed. So we're not looking just at XRP in a vacuum. We're looking at Bitcoin and Ether and how they were treated. And these are factors, ultimately, too, to consider in Ripple's fair notice defense. This is all crucial. And so I wanted to highlight this to show the judge does believe that and does understand. And that's what makes logical sense. So this is fantastic. This is very good news for XRP holders and for Ripple. And then Crypto Law also shared the following. Remember, she went on to say on April 6th that discovery into the SEC's discussions and statements on Bitcoin, Ethereum, and XRP were relevant to Ripple's fair notice defense. And here you go. And this is absolutely pure gold. This should be like music to your ears. This is what she had to say. I also think it is relevant to the fair notice defense that Ripple is raising. Yes, exactly. That's what we want. So at least there's a recognition. Doesn't mean that she will rule in favor of Ripple's fair notice defense, but there are reasons that I'm optimistic. I'm very optimistic, and it's also what just makes logical sense. I think anybody that comes in and looks at the facts of this case that are publicly available at this point, just from an unbiased perspective, would come to that conclusion. And I have confidence that's what the judge is going to find as well. We could get a bad ruling on that, and that would be very bad, which is what I'm about to talk about. But I'm for good reason optimistic. Just because historically, look at what she's been saying about this. And then Crypto Raw wrote the following. And remember, she included all communications on XRP between the SEC and all market participants and other government agencies in the scope of that discovery. So here's what she had to say on that. And again, this is a quote. I am going to authorize discovery both as to exclusively Bitcoin or Ether communications, as well as XRP communications between the SEC and third parties. And by that, I am including all market participants and the other government agencies. And so look, all encompassing basically. This is a big deal here. And so Jeremy Hogan, all up on the Twitters, was asked the following by somebody named Chloe. Tagged Attorney Jeremy at one, that's Jeremy Hogan, and wrote, which date/hearing do you think the SEC could lose that would be a major blow to their case and they'd start considering a potential settlement? Cheers. Yeah, totally legitimate question, and we're all curious about that. What would have to happen for the SEC to finally be like, okay, we've been pushing this thing, we know we have a crap case, but something has changed negatively sufficiently to make us think, okay, we need to just settle what we can, right? Before this gets even worse for us, right? Before the optics to the public and everything, so on and so forth, look horrendous. Well, here's what Jeremy Hogan said. Definitely the motion to strike the fair notice defense. If the SEC loses that, they'd have to reconsider the strength of their position. And seriously, to be clear, and Jeremy Hogan's hitting the nail on the head here, obviously. The fair notice defense, because again, if you've been following this case and the facts and circumstances surrounding this and the entire world of crypto, you know there is not clarity. Like, that's just a matter-of-fact thing. There is no participant in cryptocurrency in the United States outside of co-founder of Ethereum, Joe Lubin. Outside of him, there's nobody in crypto that thinks that there's sufficient clarity here. So it is so evident. And so this is a big deal. So the SEC at this point is hoping that the judge would happen to be in that small minority of humans, the almost 0% of humans that agrees with Joe Lubin that there is sufficient clarity. Like that, I find that so hard to believe. So hard to believe. And then so if the judge is not another Joe Lubin, then Ripple's in really good shape here. Because look, and here's what, and Jeremy Hogan talked about this too, frankly. If Ripple loses it on its fair notice defense, as in it can't be considered in this case, like there are serious consequences. For instance, and again, Jeremy Hogan talked about this. Bill Hinman's 2018 Ethereum free pass speech, that would no longer be relevant. Like, think about that. I mean, and that would just be, that's why it would be so infuriating. It would be so infuriating if this happens. And think about it, because clearly, and we already know, Bill Hinman's speech, there's a little one-liner tag, this is just my personal opinion, but it was presented in such a way that it's the official decree of the SEC. That's how the media picked up on it, and then the SEC never corrected them, and that's how everybody was reporting on it. No correction, no clarification from the SEC. Whoa, there's like, whoa, step back there, CNBC. We didn't say this was us, this is just one person here. And we know behind the scenes who was helping him write that. Jay Clayton had input all this. And Gary Gensler had input with Jay Clayton before, back years ago before he was the SEC chair. Like, there's all of this stuff. So we know that all of this is going on. And we know that the framework, actually, that the SEC put out, which is basically, again, intended to be interpreted as official SEC decree, and that's how it was taken, that framework set out there, that would indicate if it's within this framework, whatever it is not a security. XRP fits that framework better than Ethereum. And there was no ICO for XRP. That was XRP Ledger and actually fully functional before Ripple existed. It was there, right? And so that would no longer be a consideration. That's why this is such a big deal. So if Ripple's fair notice defense isn't going to stand, the judge doesn't allow it, then all the Bill Hinman stuff that we've been talking about and all the implications and all the shadiness, all of that just goes away. But that's not all. So there are 5 commissioners at the SEC that vote on whether or not to bring legal action against individuals or business entities, so on and so forth. There's just 5 of them, right? And 2 of the 5 SEC commissioners are Hester Peirce and Elad Roisman. And they have heavily criticized the SEC for their lack of regulatory clarity. Heavily. And this is important. Their perspective, if this gets thrown out, it would no longer matter. Seriously. That's 40% of the commissioners that vote on this stuff. They're saying there's not sufficient regulatory clarity. And again, that's just further proof of anything that would be evident to anybody that's unbiased with at least half a brain. Of course, there's not sufficient legal clarity here, which is why, again, I'd be shocked if the judge did not find the same thing. I'd be absolutely, utterly shocked. But the implications are absolutely gigantic. So all of that no longer matters. These perspectives from 40% of the commissioners that vote on this stuff no longer matters. It would just be gone. But see, on the flip side, if this passes, that's why it's another reason that would make it that much more likely the SEC would be like, oh, holy hell crap. We are in a bit of a pickle. We are in a jam. Oh, look at us. Yeah, well, they're going to have to come around and have a come to Jesus moment and realize that they are the asshats I've been saying that they are, and they're not good at, lawyer stuff. Like, they don't even lawyer, bro. You know what I mean? Like, they're going to have that come to Jesus moment and just give up. And then they're going to do that via settlement, and they'll be able to frame it in a way that it looks like a win, so they don't walk away optically. The optics won't be such that they feel ashamed, but inside, like, everybody participating knows, like, they'll know that they lost. That's not going to be a fun conversation for them, and the Ripple's attorneys and everybody at Ripple, they'll know, like, oh yeah, this is the SEC capitulating. That's exactly what that will be, and so that's what's at stake. And also consider this is another thing. As part of Ripple's 2015 settlement with FinCEN, so that's the Financial Crimes Enforcement Network, the U.S. Departments of Justice and Treasury declared XRP to be a currency in 2015, a currency. And this would no longer be relevant either. And so, but if it is relevant, the fact that XRP is a currency, and 40% of commissioners do say that there's not sufficient regulatory clarity, and Bill Hinman's comments do matter and all of that. If all of that's the case, yes, that's going to make the SEC rethink about settling, for sure. This is a big deal. And you know what? This is the next major motion that the judge is going to rule on. This is the next one, so we're going to find out sooner than later. And there's reason to be tremendously optimistic, but that's why I'm saying, like, with everything that's at stake here, if you get the total, that's why I wanted to lay this out in this video the way that it did, because if you understand all of these things, then you know that if the judge comes back with the right decision, which is that this defense should stand, I don't see how we don't end up with a settlement. Is the SEC actually going to risk this with all of this overwhelming evidence? I don't see it. I have a hard time saying, it's my unprofessional opinion, because, again, I don't have a legal background, but I get opinions from all sorts of lawyers in the XRP community and everybody else, even outside the XRP community, that's willing to talk about it. I absorb as much of that info as I can, and based on all of their professional opinions, I've absorbed as much as I can, and I'm just sitting here as a layperson, like, I don't see how the SEC would not capitulate at that point and just settle. I'd be shocked. So let me know what you think, but that's my take on this. And there's a reason that I feel good about this. But I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.